Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Friends, in case of contempt of court or defamation, please remember the so-called defenses should be clear and they should be of public use. If it is in the interest of public, definitely you can write some article and you can get defended also, even for defamation cases. But the language you use should be, the language and tenor should be proper. So very recently, when a case of defamation has come before the Honorable Supreme Court of India, then they have commented very badly on the journalist. What kind of language is this? The language you used and you claim you are a journalist. Justice Cant has skipped this matter. So you can see the case as D.S. VISHWANADHA Chetty versus T.N. Rathnaraj. So while disposing the criminal appeal number 9289 by 2021 on 17th December 2021, two judges bench. Cant, CGI is 3 judges, I'm sorry. Cant, Hima Kohli, and none other than our Honorable Chief Justice of India. So they refused to entertain the SLP filed by the journalist against the advocate, the appeal, right? So they don't want to interfere because the punishment given by the High Court, that is Karnataka High Court, is very, very minimal, and the type of language he used, and after looking at the language, Justice Hima Kohli said it is a typical yellow journalism. Cant also confirmed the same. CJI said the Karnataka High Court was liberal in granting 1 month conviction, 50,000 fine. He deserves more than that. Why this happened? Let us go back to the facts of the case. Actually, this appellant, Mr. D.S. VISHWANADHA Chetty, he is the editor, publisher and printer of a Kannada weekly. Many weeklies will be there. So its name is Tunga Varte. The name of the weekly is Tunga Varte. So he used to publish so many articles against or he may used to publish so many articles. Then he published several news items making baseless allegations against Rathnaraj. So he is an advocate. This Rathnaraj is an advocate. So the intention as per Rathnaraj is that to defame him and cause harm to his reputation. Therefore, he is a lawyer. He filed a case under section 500 of the Indian Penal Code. Because the complainant, being an advocate and a public notary also, the complainant alleged that the appellant used offensive and abusive language. Right. So, basing on that, he was given some notice. Then he has replied the matter, stating that in the interest of public, he has published the so-called news item. And here, please remember, the further allegation is that the same person, the appellant, was involved or he was convicted in another case of similar type, but it did not deter him from continuing publications which are defamatory. Please remember, for getting exception under section 499 of the IPC, the accused is required to prove that the publication was made in public interest or in good faith or in public good. But the investigation proved in the negative. So therefore, the trial court convicted him. Of course, the matter went to the Karnataka High Court. Karnataka High Court also was pleased to modify the sentence to 1 month and fine of rupees 50,000, out of which 40,000 has to be paid to the complainant in the particular case. So against this judgment, now he filed an SLP before the Honorable Supreme Court of India. Now we are coming to the relevant point. This conviction was given in the year 2015. This kind of language you use and you claim that you are a journalist, this is comment by Cant. Look at the language, Justice Hima Kohli. Typical yellow journalism, Cant. So ultimately, the Honorable CJI stated they were very liberal of giving 1 month conviction. He deserves more than that. So thus, please remember, you may be a journalist, you may be a lawyer, you may be a police officer, but the language and tenor used should be proper, regular, and it should not be hurt. It should not hurt the sentiments or feeling of the others, which they think that it will amount to defamation. So this is a very good case. Please read it and enrich your legal knowledge. It is a case of typical yellow journalism, and Supreme Court refused to interfere with the relief granted by the Karnataka High Court, stating that it itself is sufficient. Actually, if that be the Supreme Court, they would have given more punishment. Anyway, good judgment, read it and enhance your legal knowledge. Thank you very much.